Due Process, for the second consecutive year, recipient of Mid-Atlantic Emmy Awards for Outstanding Talk Show Series and Outstanding Public Affairs Series.
Neither the Boy Scout Charter or bylaws or even the Boy Scout Handbook say anything at all. Don't say one word about homosexuality.
Should openly gay men be Boy Scout leaders? This is an issue now before the state's highest court. I'm Raymond Brown. We'll discuss this controversial question next on Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
Should an openly gay man be a Boy Scout leader? I'm Raymond Brown. That's an issue being explored at this moment by the New Jersey Supreme Court. We'll examine it today on Due Process. So you can understand the history of this case and how it got to the state's highest court, here's a Due Process report focusing on the Boy Scouts of America and the civil rights of gays. James Dale is 28 years old. He works at Paz Magazine. He joined the Cub Scouts when he was 8 and devoted 12 years of his life to the organization, rising through the ranks to Eagle Scout and then Assistant Scoutmaster.
I was very involved in the program. It was really something that was very important to me growing up.
So it came as a great surprise when he received a letter one day stating that he had been summarily dismissed.
I was speaking at a conference on the needs of lesbian and gay adolescents at Rutgers University in my capacity of co-president of the gay group there.
A Star-Ledger reporter was there. The story appeared the next day, with James' picture prominently featured. Less than 2 weeks later, he was out of the Scouts.
I was expelled at 3 different levels, and each time they said that you're entitled to appeal this decision by a panel of your peers. 3 times they said, I want to sort of present my case, and 3 times they said, basically, we had the meetings, you weren't invited because you're gay, and it's really a moot point.
Determined to have his day in court, James appealed to Evan Wolfson of Lambda Legal Defense, a national organization devoted to upholding the civil rights of gays.
We filed the case, of course, in the lower court. The Boy Scouts succeeded in having it transferred to the Chancery Court in front of a judge named Judge McGann. He ruled against us. We appealed that decision to the Appellate Division.
The Appellate Division reversed the lower court, invoking the New Jersey law against discrimination. Under the LAD, it is unlawful for any owner, lessee, proprietor, manager, or employee of any place of public accommodation to refuse or deny to any person any of the accommodations on account of the affectional or sexual orientation of such a person.
The New Jersey law against discrimination protects people from this kind of discrimination by membership organizations that are large and that hold themselves out to the public, like the Boy Scouts.
The Boy Scouts argued that they were not a place of public accommodation. Rather, that a Boy Scout troop is a group of boys who are members of a club. They took the case to the New Jersey Supreme Court.
We have here a situation where the moral consensus in the country has become more muddled. And Your Honor is absolutely right. There are people on both sides of this issue. Boy Scouting is put into a choice in that situation. It can stick with where it was, it can move to a new position, or it can be morally relativistic and muddle along. Boy Scouts has elected to stay where it was. And
the Boy Scouts of America are caught in a societal conundrum. Scout leaders see homosexuality as morally objectionable. The American public is somewhat ambivalent about gays, preferring, like the military, a don't ask, don't tell approach. Boy Scouting has followed the same line. The problem for James Dale was that his gayness became public.
What I thought you said was that the Boy Scouts' opposition was not so much to admitting a boy who may be a homosexual as it is to one who is a homosexual and expresses support for his homosexuality.
The Scout leader is supposed to be a model of living the law, the oath and law in your daily life.
The position of the Boy Scouts, as I understand it from you, is that what they're really concerned about is the expression of a view that conflicts with your description of the Boy Scouts' position on homosexuality.
You know, our concern is with the message that's conveyed to kids about what sort of behavior is appropriate.
James Dale is the perfect embodiment of everything they are trying to role model. He is honest, he is cheerful, he gives back to the community. What they, through their lawyers, are trying to do is add in something that doesn't appear anywhere. So yes, they're entitled to want good role models, but no, they're not entitled to put their own prejudices in.
In the Boy Scouts, they taught you to stand up for what you believe in, to stand up for what's right, and that you know what's right, and sometimes your peers might not agree with you, but you know down deep inside, and that's definitely the situation here.
But the Scouts claim that what Dale is doing violates their First Amendment rights. If they're forced to take Dale back despite his opposition to their anti-homosexual policy, their rights as an organization would be infringed. It would violate the Scouts' right to choose the content of the organization's own message. The conflict is joined over who controls the message.
We're hopeful, of course, that we'll have a decision soon, and we're, of course, hopeful that that decision will be in our favor and bring an end to this ugly discrimination and really keep the Boy Scouts true to what they teach the members.
No matter how the New Jersey Supreme Court rules, both sides expect there will be an appeal.
This isn't about bullying my way into a troop that doesn't want me and doesn't value the contributions I have to give. I think this policy is hateful and hurtful and damaging to a lot of kids out there, and it's teaching them the wrong thing. So I know ultimately that the policy is going to be changed, and hopefully either I can benefit out of that or other people can benefit out of that.
But is it inevitable that the Boy Scout policy will change? Should that issue be decided by the Scouts or in the courts? Does a gay man or boy, for that matter, have a right to be in Scouting without having to hide his sexual orientation? We'll explore these and other questions with guests who care passionately about them as Due Process continues.
There shouldn't be no discrimination at all. I mean, it's an organization, everyone should be the right to be in there. I think gays, straight, anybody have the option to be there.
Whether you're gay or not, you could be in the Boy Scouts, as far as I'm concerned. Once you start holding a banner saying, I'm gay, and also tying it into the Boy Scouts, I think that's the wrong thing to do.
If the label is just that a kid is gay, but there's no gay activity going on, if that makes sense, then I guess it's okay.
As long as he could respect himself and the children and be open about it, or they should have somebody there with that person while he's doing his job. You know, I don't think that he should be expelled or treated less for any reason just because his preference and lifestyle.
The controversy surrounding gay rights has touched many areas of society in recent years, from the military to adoption. Now the New Jersey Supreme Court is set to decide whether the Boy Scouts can bar an openly gay man from Scout leadership. Here in Trenton to discuss that issue is Lewis Robertson, a civil rights leader, a West Pointer, and one of the lawyers who represented the plaintiff in the current Scouting case, James Dale. Robert Rochford, a New Jersey trial lawyer who represents several religious groups that were friends of the court in the James Dale case. And joining us from Newark is David Rocha of the New Jersey ACLU. He was also a friend of the court in the James Dale case. Bob, let me start with you. The question that I guess poses itself is, was Mr. Dale the ideal Scout leader until the day that he publicly proclaimed his homosexuality and then became undesirable? And if so, what principle governs that?
He was a reasonable role model until he became an advocate for homosexual conduct, and as an active practicing homosexual, ceased to be a role model that was consistent with the traditional Judeo-Christian ethics and religious principles that underlie the Boy Scouts.
And so the issue really is joined then when he begins to express or advocate gay rights or other issues related to homosexuality.
Well, precisely, because all of the leaders in the Boy Scouts have to be deemed to be role models. And in allowing a leader who is openly gay to function within the organization, he is deemed to become a role model, and there's an implied, it's not explicit, endorsement of his conduct and his choice of lifestyles.
Is, in fact, the presence of Mr. Dale as a Boy Scout leader and a person who has openly proclaimed his homosexuality an endorsement or an inducement to others to embrace his lifestyle?
I don't think so. First of all, we have to understand that James Dale, it became known that James Dale was homosexual, not in the context of any activity having to do with scouting. There was no attempt by James Dale to communicate the fact to, for example, members of his troop that he was gay. There was no advocating on the part of James Day of any sort of homosexual conduct or lifestyle within the context of scouting. He was simply a student of Rutgers University who happened to be gay and was concerned that other gay teens have information about issues that affect gays.
How do you respond to the argument that Bob makes and that Scouts make that they have a particular set of principles or moral concepts that exclude certain kinds of conduct, and if you're going to endorse that conduct, you shouldn't be a Scout?
Well, again, I would disagree that James Dale, simply by acknowledging that he was gay, was endorsing gay conduct to others who perhaps were not gay. He was simply acknowledging that this was one of his several immutable characteristics. And again, it was outside the context of scouting. I'll leave it at that.
Dave, let me bring you into the conversation. You represent a group that really isn't involved with scouting and isn't necessarily involved with the gay rights movement, but thinks there are some issues of public concern. That's why you're a friend of the court. What is there an issue that transcends this particular case and is of broader importance for the rest of society that motivated you to get involved?
Well, I think there are two important issues here that motivated our involvement in the case. One is on the question of the definition of a public accommodation for purposes of New Jersey's law against discrimination. It would be ironic in the extreme if an organization with over 5 million members would be held not to be a public accommodation. And I think it would be very detrimental to New Jersey civil rights law if that decision were made. Second of all, assuming that the Boy Scouts are a public accommodation, the question then becomes, are they entitled to some kind of broad-based exemption from generally applicable civil rights laws because they want to have this discriminatory policy? We believe the answer to that question is no. The fact that there are clearly people within scouting who want to discriminate against gays does not mean that the Boy Scouts as an entity are entitled to an exemption from, as I said, a civil rights law of general application.
Bob, let me ask you this question. I believe that if a person who was a Buddhist, for example, you'd mentioned the Judeo-Christian ethic, but if a practicing Buddhist wished to become a Boy Scout or a Boy Scout leader, there would not be an objection.
Oh, there's none at all. There is a requirement that you believe in God.
So a practicing atheist, there would be a similar challenge.
That is correct.
With respect to where you draw the line, you think that the Scouts have the right to make their own judgment about who can or cannot become a Scout leader?
Well, they have the right to define what their underlying principles are and what the goals of their organization are.
Well, why wouldn't they have the right?
And rather, without having the courts redefine those principles and redefine those goals. You know, what's happening here is that we're having a set of principles that's been inconsistent with scouting practices from the day of Baden-Powell, who was the founder of the organization. He's the founder of the scouting movement. We're having practices that are inconsistent with all the history of scouting, rammed down the throat of a private organization. It is open to the public, but it's open to those people in the public who adhere to our moral principles. And why should the courts be the ones to tell us to change the moral principles? Remember, the organization decides what its moral principles are. And all of these different groups have an ability to work within the organization to change. But they're a tiny minority.
Why should it be the courts rather than the Scouts who make this ultimate decision?
Well, first of all, the law against discrimination was adopted to preclude even private organizations from enforcing discriminatory practices predicated primarily on immutable characteristics: gender, age, sex, things that you really have no choice in. It's a very important objective because being discriminated against causes humiliation, it causes economic harm, and to that end, the law against discrimination was adopted to totally eradicate it in New Jersey if that's possible. Secondly, we have to think in terms of whether or not there's some sort of attack or some sort of degradation of a core principle of Scouting. And so we should look to Scouting's basic documents to discover what their core principles are.
So you dispute Bob when he says this is one of the basic principles that defines Scouting?
I dispute it for a couple of reasons. First of all, if you look to their congressional charter, which was adopted in 1915, it says nothing that suggests that views antithetical to homosexuals has had anything to do with the original formation of the Boy Scouts. It's not in the bylaws, it's not in the mission statement, it's not in the handbooks that are disseminated to Boy Scouts, it's not in the handbooks that are disseminated to Scout leaders. The first written expression of any sort of antipathy towards homosexuals was in the form of a position statement given by the national organization to its executive council. And essentially what it said was that since Scouting is a privilege, not a right, and we consider homosexuality to be inconsistent with Scouting, we will not accept acknowledged homosexuals as Scout leaders.
Is that a recent pronouncement?
That's a 1978
Bob,
pronouncement.
what's then to keep Scouting from shifting its principles to exclude other groups on the basis of whatever current feelings it has about the conduct that it likes?
We would suggest that on a First Amendment basis, with freedom of association, an organization has every right to make the decision. For example, if an organization, a religious organization, at one time believed that blacks were inferior, and then changed its principles and said, we recognize that all men are equal, then we'd applaud that taking place, wouldn't we? It's the organization's decision that has to be made, not the courts and the government stifling the ability of the ability of organizational due process and organizational democracy to take place. And I'd very much call your attention that at the time of the congressional charter and the early documents that were created governing Scouting, homosexual conduct was a crime. There was as much need in those documents to say that homosexual conduct was inconsistent with Scouting as there was a need to say that murder, arson, and burglary were inconsistent with Scouting. And for 21 years, Scouting has defended this position.
But Scouting championed loyalty to country, which is a pretty settled principle, both legally and morally. So let me ask you this question, though. It sounded to me like you were calling Dave's name, because you started talking about the First Amendment. Dave, if Bob wants to say the First Amendment is the principle on which Scouting stands in this battle, how come you're not on his side?
Well, it's a misplaced argument in this case. I mean, that's the crucial issue. You know, I think first we need to address your initial question, why are the courts involved? The courts are involved because what they want to do here is illegal. It's been declared illegal by the legislature of the state of New Jersey, which said that a place of public accommodation cannot discriminate on the basis of sexual orientation. If we start from that point, and if we can move beyond the debate as to whether or not the Boy Scouts are in fact a place of public accommodation, an issue that did not seem to trouble our state Supreme Court at oral argument much, and an issue on which I think there can be very little room for debate. Then the question becomes, as I said earlier, are the Boy Scouts entitled to some kind of exemption from this this law of general application, this civil rights law? And the answer to that question lies in a trilogy of Supreme Court cases, which says if you want to have an exemption from an anti-discrimination statute, that may be required by the First Amendment in certain very narrow circumstances, but it's required if and only if the organization's expressive and associational purpose will be destroyed by enforcing the anti-discrimination provision.
Now, this case was argued in front of the state Supreme Court. We're, as we sit here now, expecting a decision. And it sounds as though the critical question is what was the function and the prime purpose of the Boy Scouts, and how close to that prime purpose is this concept?
Right, and let me just add one more thing to that, which is that even the Boy Scouts' own lawyer at oral argument conceded that the Boy Scouts would not seek to exclude the hypothetical celibate priest who advocated gay rights and acceptance of homosexual conduct. So this case has nothing to do with views. There are tens of thousands, if not hundreds, or perhaps even millions of people within Boy Scout who hold no anti-gay views whatsoever. And there are certainly an equally large number of people who, in fact, have specifically advocated within Boy Scouts itself to end this discriminatory policy.
David, so I wanted to get Bob's reaction to that, because it does seem, Bob, as though your position is a fairly narrow one. By that I mean you're saying only a very narrow category of people would be excluded. It's hard to understand the rationale.
Well, the rationale is that those individuals who would be excluded are not individuals who, as models, are engaged in conduct, which is part of the educational process for our Scouts that's consistent with our principles, namely traditional religious values. And I heard a lot about all these people in Scouting that are supportive of or indifferent to the position of Mr. Dale. The fact is that roughly 65 to 70% of all Scout troops are sponsored by religious organizations, and roughly the organizations representing roughly 50% of all Scout troops, religious organizations, have supported specifically the position of the Scouts in this case. The religious organizations that have supported Dale represent a tiny, tiny minority within the organization itself. If someone believes in democracy, those folks ought to be trying to convince the rest of the Scouting movement.
All right. It would be nice to be able to get into the numbers, but let me do this. What all of us know is that it's perilous to predict what a court will do from the legal argument. I suspect we've all been wrong about that at one point in our lives. But I got to ask you, Louis, whether based on what happened at the argument and the attitude that you sensed on the court, that's all we can ask about, what would you think is the decision? Not what do you think, not what do you feel, because we know which side you're on, but what do you think is likely to happen with this court?
My impression was that a good many of the justices were skeptical of the Boy Scouts argument. And if I were going to have to hazard a guess one way or the other, I would say that the Supreme Court is likely to affirm the appellate division.
Bob, I know that's not a result you'd like, but what do you think is likely based on your presence and your attempt to read the court, understanding that it's a difficult?
Given the fact that the U.S. Supreme Court came down with the Hurley case, which basically casts an awful lot of light, also an awful lot of doubt on the cases that Mr. Rocha was talking about, I think it's a 50-50 call, and whatever happens, we're going up.
There's
to
another
Washington.
Supreme Court that'll be hearing from this. David, I can't let you pass this by without asking you your prediction as to where you think this court is going to go. Not what do you think they should do, but what will they do?
Well, my own personal feelings about the case aside, I would have to agree with Louis based on the tenor of the justice's questioning at the oral argument.
But would it also be fair to say that if this case winds up in the United States Supreme Court, it's almost a new game in the sense that that court may take a different view?
I don't, you know, I think that the answer here is fairly clear, and I think the record here is fairly clear, and I don't think that this case is as difficult as some would like to portray it.
We're winding down, Bob. I assume you think it's clear that the United States Supreme Court would rule in the Scouts' favor, or at least be a different level of analysis and a different receptivity?
Absolutely, and keep in mind that California has already sustained the Scouts on this exact issue.
And Louis, I assume you have a different view on the United States Supreme Court, that it would be a...
I do.
Okay.
I do.
We've got to go. I wish we had time to discuss it further. I have a feeling we'll come back to this issue because it's important and the courts are still wrestling with it. But that's it for this edition of Due Process. Be sure to join us next week when our docket will include yet another look at law and social justice. Till then, for all of us here at Due Process, I'm Raymond Brown.
What this is all really about is states like New Jersey have civil rights laws. Those laws say that people should be judged based on what they do, what they contribute, whether they follow the rules, not based on who they are. And that large organizations like the Scouts, particularly when they go into the schools and into the fire departments and the military, should not send a message, should not themselves discriminate when the law says that all people should be treated equally. That's what this case is about. It follows directly in a long line of civil rights cases on behalf of other people who similarly face prejudices and stereotypes. And frankly, we're in a much better America today because those people stood up for themselves, and James is following right in that tradition, just like the Scouts taught him.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.